Good morning. My name is Gautam Bhatia. I work at the High Court of Delhi, and I will be discussing within the comparative constitutional law module the part on life and personal liberty. Let us introduce the subject. Most constitutions have grown out of colonial experiences involving arbitrary imprisonment, arbitrary detention, and similar other excesses by the colonial governments, sometimes even execution. These have been staple features of the governing regime. Consequently, it is hardly surprising that the right to life and personal liberty occupies a central place in bills of rights. In the Indian and American constitutions, for example, this right is framed as an express prohibition upon state action. For example, under the 14th Amendment to the United States Constitution, it is stated that nor shall any state deprive any person of life, liberty, or property without due process of law. Similarly, Article 21 of the Indian Constitution states that no person shall be deprived of his life or personal liberty except according to procedure established by law. The Canadian Charter on Rights and Freedoms has an interesting variation, guaranteeing that the right to life and liberty and security of the person and the right not to be deprived thereof except in accordance with the principles of fundamental justice. So, you see that there is a prohibition upon the state depriving a person of their life or personal liberty, while at the same time allowing that deprivation subject to certain constraints. On the other hand, the South African and German constitutions, for example, have chosen to express this right not in a negative sense, that is, as a restriction or prohibition or limitation upon state action, but in a positive form, that is, as an entitlement that the people have. So, for example, under Article 2, Clause 2 of the German Basic Law, it is guaranteed that every person shall have the right to life and physical integrity. Freedom of the person shall be inviolable. These rights may be interfered with only pursuant to a law. Similarly, the South African Constitution provides that everyone has the right to life, section 11, and that everyone has the right to freedom and security of the person, section 12. Now, as we discussed a little while ago, given that arbitrary detention and arbitrary deprivation of liberty was a central feature of colonial regimes, the first aspect to examine is the relationship between personal liberty and arbitrary detention. And so, the central meaning of the right to life and personal liberty is found therefore in the freedom from arbitrary detention, which, as we mentioned above, was a staple feature of colonial regimes and also one of the most important issues in liberation struggles. To this end, often accompanying the right to life or personal liberty, constitutions have provisions that regulate or prohibit detention. For example, Article 22 of India's Constitution, which prescribes the procedures for preventive detention, immediately follows Article 21, which guarantees the right to life and personal liberty. Similarly, the European Convention on Human Rights and the German Basic Law have prohibitions against arbitrary detention in the close vicinity of the right to life and personal liberty. For example, Article 5 of the European Convention of Human Rights states that everyone has the right to liberty and security of person. That same article in its third clause further states that everyone arrested or detained shall be brought promptly before a judge or other officer authorized by law to exercise judicial power and shall be entitled to trial within a reasonable time or to release pending trial. This, of course, is motivated by an idea that repressive regimes often use detention as a simple way of holding individuals captive without the necessity of bringing them to trial and actually proving charges against them. Let us now focus upon an interesting and controversial area of law closely connected with the right to life and personal liberty, which is the idea of when you can deprive people of those rights, specifically the idea of due process. Under the American Constitution, deprivation of life or liberty must take place only under due process of law. Under the Indian Constitution, it must take place only in accordance with procedure established by law. Now, the key question is, what meaning do we give to these terms? Due process of law, procedure established by law. And this has an interesting history. Around the turn of the 20th century, American Supreme Court judges invoked the Due Process Clause to strike down a series of social welfare legislation that aimed at mitigating some of the worst evils of the laissez-faire economy, on the ground that such laws interfered with the liberty of contract. In the most notorious of these cases, Lochner versus New York, the Supreme Court struck down a law that regulated the working hours for bakers with the objective of preserving their health and time. This position was eventually reversed, but 50 years later, progressive-minded American judges similarly used the Due Process Clause to strike down socially regressive legislation, such as the prohibition of contraceptives, interracial marriages, and so on. For example, in the case of Loving versus Virginia, in striking down a prohibition on interracial marriage, the court held, marriage is one of the basic civil rights of man, fundamental to our very existence and survival. To deny this fundamental freedom on so unsupportable a basis as the racial classifications embodied in these statutes, classifications so directly subversive of the principle at the heart of the 14th Amendment, is surely to deprive all the state citizens of liberty without due process of law. The 14th Amendment requires that the freedom of choice to marry not be restricted by invidious racial discrimination. Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state. Presently, under American law, in a due process challenge, the court will examine whether a particular liberty is what they call deeply rooted in American history and tradition, and will strike down the infringing law if it is. For example, in a case called Pierce versus Society of Sisters, the Supreme Court held that the liberty of parents to bring and guardians to direct the upbringing and education of children under their control was one such basic liberty that was part of the American tradition, and therefore struck down a law that did not allow that. Let's now move to the phrase procedure established by law, which we find in the Indian Constitution. At the time of the drafting of the Indian Constitution, Justice Felix Frankfurter of the American Supreme Court was one of the many experts who was consulted about the language of the Bill of Rights. Drawing from the American experience with the Due Process Clause, he advised the Indian drafters to leave no scope for manipulation and not insert the phrase due process at all. Frankfurter was a conservative judge who was a strong advocate of judicial restraint, and therefore he was against the expansive use that the court in America was making of the Due Process Clause. And based upon Frankfurter's recommendation, in the Indian Constitution, Article 21 uses the words procedure established by law instead of due process of law, something that was extensively debated upon in the Constituent Assembly debates. In the case of A.K. Gopalan versus State of Madras, this question was addressed by the court. In that case, the court held, in Article 21, the word law has been used in the sense of state-made law and not as an equivalent of law in the abstract or general sense, embodying the principles of natural justice. The article presupposes that the law is a valid and binding law under the provisions of the Constitution, having regard to the competency of the legislature and the subject it relates to, and does not infringe any of the fundamental rights which the Constitution provides for. Therefore, in Gopalan and similar cases, the court construed the phrase procedure established by law in a very narrow sense, simply as referring to a law that was validly enacted following all the procedures in Parliament and which did not infringe other fundamental rights. However, in the late 1970s, there was a sea change in the court's jurisprudence. Swinging the pendulum all the way to the American substantive due process position, the court held that the law referred to by Article 21 must be a just, fair and reasonable law. Parallel to this, the court expanded the scope of the term life and personal liberty in Article 21 to cover a whole host of matters relating sometimes tenuously to the human condition. According to the court, decent treatment of prisoners, an adequate livelihood and a pollution-free environment were all guaranteed under Article 21. Let's now consider the distinctions and the differences between how the American Constitution and the American courts have understood their expansive reading of substantive due process and how the Indian courts have gone about the same enterprise. Now, the crucial distinction between the substantive due process jurisprudence of the American and the Indian courts is that in the US, the concept of liberty is deeply rooted within American history and tradition, serves as some kind of a corrective or a check upon reckless judicial expansion of the phrase life and personal liberty. Those who challenge a law must demonstrate, using rigorous historical evidence, that the liberty they claim is not a novel innovation, but one that has been implicit in American society all along, even though it is not expressly guaranteed by the constitutional text. By contrast, the lack of such a corrective in India's Article 21 jurisprudence has ensured that the life and personal liberty clause has become a catch-all and has led to numerous accusations that it is now merely a front for judges to smuggle in their own political preferences into law as they see fit. In the absence of any constraining feature, any constraint or limitation upon how the phrase life and personal liberty is to be understood, such accusations are inevitable and have more than a ring of truth to them. Let's now consider the issue of positive liberties and to what extent Article 21 contains, or other such guarantees of the right to life, contain within those provisions positive guarantees. The Canadian Supreme Court, for example, has been very circumspect in recognizing any positive rights under its broad guarantee of life, liberty and security of person. In the case of Gosselin versus Quebec, for example, the Supreme Court held that special circumstances must be demonstrated in order to read in positive rights into Section 7 of the Canadian Charter of Rights and Freedoms. The European Court of Human Rights has also interpreted positive rights to apply to a highly circumscribed range of cases. For instance, in Osman versus the UK, where a man was shot dead by another individual, the question was whether the English, the state, the United Kingdom, had breached its obligation to ensure that Osman's life was adequately protected. The European Court of Human Rights held that there was a positive obligation upon the state in limited cases where the authorities knew or ought to have known at the time of the existence of a real and immediate risk to the life of an identified individual from the criminal acts of a third party, and that they failed to take measures within the scope of their powers, which, judged reasonably, might have been expected to avoid that risk. So, as we can see, the interpretation is very limited. There must be an identified person to whom there must have been a real and immediate risk to his life, and that from the criminal acts of a third party, and given all that, the state failed to take reasonable measures for avoiding that. So, you can see how it is a very narrow and limited reading. Let us now move to our second broad topic, which is the idea, the controversy surrounding abortion. Constitutional debates over abortion normally involve a clash between two stated values: the rights of a prospective mother to privacy, bodily integrity, autonomy and sexual choice, and the right to life of the unborn fetus. At a preliminary level, one important question is whether the constitutionally guaranteed right to life extends to the unborn. Insofar as the right to bodily autonomy is itself treated as an aspect of the right to life and personal liberty, abortion cases then potentially involve the clash of two competing rights to life: the right of the mother and the right of the fetus. For the most part, however, the courts have dodged the question of whether the clash is between the right to life of the woman on the one hand and of the fetus on the other. The exception is South Africa, where it was expressly held that the phrase "everyone has the right to life" does not include unborn life. So, everyone does not mean a fetus. That has not been what most courts have done. Rather, they have framed the issue in terms of the state's interest in protecting all life, even unborn life. This has been the American Supreme Court's approach, for instance, in the world famous case of Roe versus Wade. In that case, the court read in a right to privacy into the American Constitution interstitially, that is, a right not expressly guaranteed by the constitutional text, but implicit from a combined reading of a number of provisions, including those guaranteeing life and liberty. It then held that the woman's right to privacy would have to be balanced against the state's legitimate interest in protecting life. This balance, according to the court, lay in adopting a trimester system, where abortion is permitted in the first trimester of pregnancy, but regulated after that, when the state's interest in protecting life is deemed to either balance out the women's rights or to override it. Similarly, the German Constitutional Court has held that its Bill of Rights not only guarantees negative liberties from coercive state action, but also constitutes an objective order of values which state action must conform to. One of those values, according to the German Constitutional Court, is the state's duty to protect and foster all life. For this reason, the German court held that there must be legal condemnation of abortion, even though it need not necessarily take the form of a penal sanction or jail time. According to the court, the duty of the state to protect every human life may therefore be directly deduced from Article 2, Paragraph 2, Sentence 1 of the Basic Law. In addition to that, the duty also results from the explicit provision of Article 1, paragraph 1, sentence 2 of the Basic Law, since developing life participates in the protection which Article 1, paragraph 1 of the Basic Law guarantees to human dignity. Where human life exists, human dignity is present to it. It is not decisive that the bearer of this dignity himself be conscious of it and know personally how to preserve it. The potential faculties present in the human being from the beginning suffice to establish human dignity. And we can see therefore how the constitutional courts in the US, South Africa, Germany have gone in different directions and taken different approaches to understanding what rights are at stake in abortion cases and what framework must be used to understand the connection between abortion and the right to life, personal liberty, autonomy and privacy of the woman and potentially of the fetus. Let's now consider our next issue, which is the issue of capital punishment or the death penalty. Notice that, as we've seen before, the right to life in constitutions is not absolute. It can be taken away. The government can deprive individuals of the right to life in accordance with law. The question therefore is, to what extent is the death penalty, which amounts to taking away the right to life altogether, consistent with the right to life in a constitution? Now, in the US, which retains the death penalty, the 14th Amendment, which guarantees the right to life and liberty, by its very phrasing envisages that the government can take it away as long as it follows due process, which we discussed a little while ago. The constitutional terrain on which the issue has been contested has been the closely allied right against cruel and unusual punishments. The prohibition of cruel and unusual punishment stems from a concept that is run closely together with the right to life and liberty, that is, the sacrosanct value of preserving the dignity of all individuals. We saw a little while ago how the German Constitutional Court understood the abortion controversy within the framework of preserving and fostering human dignity, and that's something that's played a major role in the capital punishment cases all over the world. So in the US, the argument has been between originalists who hold that since at the time of the framing of the American Constitution, death penalty was clearly not a cruel and unusual punishment insofar as the framers inserted that term into the Constitution. It was being practiced by governments across the board. Clearly, therefore, the meaning of cruel and unusual does not include death penalty. On the other hand, it's argued by living constitutionalists that evolving standards of decency now place the death penalty beyond the pale of legitimate state punishment, whatever might have been the case earlier in the 1700s. In America, while the death penalty was briefly placed in moratorium in the 1970s in a famous case called Furman versus Georgia, that lasted only 4 years and was that position was changed in the case of Gregg versus Georgia. So as of now, broadly, the constitutionality of death penalty is accepted in the US, and the move has been to limit its application as well as improving upon procedural safeguards. So for example, death penalty to minors, death penalty to insane people, death penalty for crimes that do not involve murder or taking the life of the victim have gradually begun to be phased out via the judiciary. On the other hand, the case of S versus Makwan-Yane, the court examined the constitutionality of the death penalty on the touchstone of the right to life, the right to dignity, and the right to equality, and held that all these rights inform the content of the guarantee against cruel and unusual punishment. The court held, and I quote, "The carrying out of the death sentence destroys life, which is protected without reservation under section 9 of our Constitution. It annihilates human dignity, which is protected under section 10, elements of arbitrariness are present in its enforcement and it is irremediable. Taking these factors into account, I am satisfied that in the context of our constitution, the death penalty is indeed a cruel, inhuman and degrading punishment. So, we can see how South Africa, on a combined reading of its life, liberty, dignity clauses, outlawed the death penalty as violating the constitution. By contrast, in India, the Supreme Court has held that the death penalty does not contravene the right to life and is not a cruel or unusual punishment. Not only has the Indian Law Commission recommended the retention of the death penalty, but the Indian Supreme Court also noted that in light of the fact that the constitutional framers clearly envisaged death penalty as a mode of criminal punishment, open quote, by no stretch of the imagination can it be said that the death penalty, either per se or because of its execution by hanging, constitutes an unreasonable, cruel or unusual punishment prohibited by the constitution. The Supreme Court has held, however, that the death penalty can be imposed only in the rarest of rare cases. But what constitutes the rarest of rare case has subsequently been open to diverse interpretations, and the position of law right now on that is rather unclear. Let us now turn to our last topic in this module, which is the relationship between the right to life and personal liberty and the ideas of privacy, autonomy and dignity. As you have seen before, courts often run together ideas of life and personal liberty and that of dignity. We saw it in the German Constitutional Court's decision on abortion, we saw it in the South African Court's decision on capital punishment and so on. Dignity in turn is related to other important values such as privacy and autonomy. Under the broad heading of life and personal liberty, these concepts have played an important role in constitutional adjudication. In India, notions of privacy and dignity have been explicitly read into Article 21. The Supreme Court has famously held, for instance, that the right to life means not merely an animal existence, but a life with dignity. Over a series of decisions, the Supreme Court has also held that Article 21's right to personal liberty includes a right to privacy, both against intrusive state surveillance as well as intrusive individual prying into one's affairs. So, for instance, in cases like Khadak Singh and Gobind, the court held that surveillance by the state can be justified only if there is a compelling state interest and that the surveillance itself is tailored narrowly. In Gobind, the court held, and I quote, "Any right to privacy must encompass and protect the personal intimacies of the home, the family, marriage, motherhood, procreation and child rearing." This catalogue approach to the question is obviously not as instructive as it does not give an analytical picture of that distinctive characteristic of the right of privacy. Perhaps the only suggestion that can be offered as a unifying principle underlying the concept has been the assertion that a claimed right must be a fundamental right implicit in the concept of ordered liberty. So, we see how at the end the court explicitly links privacy with liberty and holds that ordered liberty ensures or requires that a right to privacy be protected at all times. The confluence of privacy, dignity and autonomy has led to some path-breaking decisions in the domain of private sexual conduct. Lawrence versus Texas, for example, is a famous American constitutional case in which the state of Texas's sodomy, i.e. anti-homosexuality law, was struck down as violating the due process clause discussed above. The court held that, quote, "Liberty protects the person from unwarranted government intrusions into a dwelling or other private places. In our tradition, the state is not omnipresent in the home, and there are other spheres of our lives and existence outside the home where the state should not be a dominant presence. Freedom extends beyond spatial bounds. Liberty presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate conduct. The instant case involves liberty of the person both in its spatial and more transcendent dimensions. So, we see again how liberty and autonomy are closely linked, and ultimately how sexual orientation and the freedom of sexual conduct is connected by the court to a broad idea of personal liberty. Similarly, in South Africa, the rights to privacy and dignity have been instrumental in overturning anti-homosexuality laws as well as restrictions on same-sex marriage. In National Coalition for Gay and Lesbian Equality versus Minister for Justice, the South African Constitutional Court noted that privacy recognizes that we all have a right to a sphere of private intimacy and autonomy, which allows us to establish and nurture human relationships without interference from the outside community. The way in which we give expression to our sexuality is at the core of this area of private intimacy. Sodomy laws are a severe limitation upon the gay man's right to privacy, dignity, and freedom. So, we see again how the court links privacy, dignity, and freedom and decides the case on that basis. When we are studying the right to life and personal liberty in a comparative constitutional context, the following themes emerge from the above discussion. First, what is the scope of the right to life and personal liberty? In other words, what concrete guarantees to the individual are contained within the broad terms life and personal liberty? We have seen that while these rights originally emerged as a reaction to arbitrary state imprisonment and or execution, they have evolved to now be understood as a guarantee of autonomy, dignity, and privacy to all individuals. Autonomy and dignity, however, remain broad terms. Specifically, we have seen that privacy from state surveillance, sexual freedom, and the removal of the death penalty as a form of punishment are some of the specific ways in which courts have cashed out these terms. And to conclude now, a question that we must ask ourselves is whether the right to life and personal liberty are simply meant to act as checks or barriers upon coercive state action, or whether they are positive entitlements that go towards securing a good or dignified life for all citizens. While there have been a few hesitant moves towards adopting the second understanding, by and large, constitutional courts have limited the right to life and personal liberty to the negative domain. The significant exception to this general rule is India, where the courts have carved out a host of positive entitlements such as the right to livelihood and the right to a pollution-free environment out of the negative wording of Article 21. The future course of these rights remains open. Thank you.